Yesterday's oral arguments on the anti-terror law ended on a high note. Out of 37 petitioners, only 7 representatives were allowed to deliver their arguments before the 15 magistrates. One petitioner is Albay Representative Edsel Lagman, who argued that the provision on a 14-day detention without a warrant is unconstitutional. Human rights lawyer Chel Diokno, on the other hand, argued that if the Anti-Terrorism Act existed back in 1986, then Archbishop Cardinal Sin's call for people power would have easily qualified as inciting to terrorism.
If this law had existed in 1986, Archbishop Cardinal Sin's call for people power would easily qualify as inciting to terrorism.
Justice Marvic Leonen says he understands the fears of the petitioners because he himself experienced this back when he was still a public interest lawyer. But Leonen did question whether the petitions were ripe.
Whatever the intentions were in this provision, isn't it the role of the judiciary to give a chance to the political department to be able to address the harm that they wish to address before we come out immediately on a theoretical point to actually to annul that provision?
Your Honor, my humble submission is that deference, judicial restraint ends where the Bill of Rights begins.